Hello YouTubers, Joe Kersey here on Wednesday, June 29th, 2016 at 14:50 in the afternoon. Yeah, I know the clock behind me says 14:45, but it's 14:50 in the afternoon. Eastern time. Now, yesterday I put up a video of asking just a fun thing that occurred to me. You know, this hypothetical law school tort question based on a set of circumstances that Paul had been involved in a couple days before, and I said, send in your answers. Well, it turns out we have an answer. And I do know the fellow who sent me this answer response. He's an attorney who's had decades, well over 40 years of legal experience both as a working attorney and also then as a common pleas court judge. No, not the fellow that handled my eminent domain case. No, not any attorney that I've ever used before. So I thought I'd elaborate on this. Now I'll put the link to the questions, in the little description box below. But as you recall, it involves an individual who had, while Paul was backing into a parking space, an individual who had walked into the potential space between the two vehicles, between her car and his truck. He was backing in. She had parked facing in. And while he was backing, in the act of backing, she just opened the door and quite unexpectedly, clearly. And, he ran into the door. So, who's negligent? Who's at fault? Who pays? That sort of thing. So, this respondent says, or answers, or offers this answer. Great question. However, although it may seem obvious, at least it appears to me that the vehicles were headed in opposite directions. Yes, in the parking area. Thus, the passenger side rear door of the pickup truck striking the passenger side rear door of the pickup truck striking the passenger door of the car. The vehicles have to be headed in opposite directions, as indeed they were. Headed meaning pointing, although Paul was heading, the individual who was parked, but she had headed in the opposite direction. As a general rule, and I'm sure you full well know, operators of motor vehicles are imposed with a statutory and common law duty to exercise due care in the operation of the vehicle in order to avoid injuring other persons or property. Likewise, persons such as our hypothetical plaintiff, the woman whose door was hit, who opened the door and the door was hit. Likewise, persons such as the plaintiff are charged with a common law duty to avoid doing, as well as refraining from doing, an act which might cause injury to himself, herself, or others. In this case, the operator of the pickup, the hypothetical defendant, had a duty to look and thus observe the lady headed toward the car door and to stop. Clearly, the pickup driver should have stopped and checked what the lady was going to do before he completed his parking efforts. So it looks like we have a duty, continue to look and see, a breach of that duty, and some injury, property damage. But was that breach of duty the proximate cause of the property damage about which the plaintiff/lady complains? And here we go with another twist. The plaintiff, lady, was also under a common law duty to refrain from doing some act that might conceivably cause injury. She was under a duty to observe the pickup backing into the parking space immediately beside her car and to avoid taking any steps that would surely cause property damage, i.e., don't open the passenger door in the way of an adjacent moving vehicle. Here also, it looks like we have a duty, look and see the rear end of the truck. A breach of that duty and some injury, property damage. Again, was that breach of duty the proximate cause of the property damage about which the plaintiff lady complains? How interesting, both parties essentially admitted fault. And it is well settled that there can be more than one proximate cause. That's something that is almost counterintuitive, and I hadn't really appreciated that. In this particular case, at least in my opinion, the concept of comparative negligence would come into play. The finder of fact, jury or judge, would find that the defendant truck driver was more than 50% negligent if the finder of fact would find that the defendant truck driver was more than 50% negligent, then the plaintiff lady would prevail to the tune of whatever percentage of negligence was assessed to the defendant. If the finding was 50-50, then no recovery would be allowed. While the wily ways of insurance companies have always been somewhat of a mystery to me, I can see that the truck driver's carrier proclaiming that the accident was all the lady's fault for opening the passenger door right into the path of the rear of the pickup truck. That's a bit awkward. You can see the truck driver's carrier proclaiming that the accident was all the lady's fault for opening right. Of course, from the perspective of the plaintiff's carrier, that carrier would maintain that the pickup truck driver should have known, or reasonably known, that the plaintiff would open the passenger door and should have been on the lookout for that action. Now, I'm just going to add here that I think anybody who does that's basically a moron. But I digress. Lawsuits are quite expensive for insurance carriers in the form of attorney fees. Oh, don't we know that? So in all likelihood, it is conceivable that the pickup truck's carrier might throw out a carrot and say, look, we will pay somewhere around half of the plaintiff's property damage. In the final analysis, the plaintiff might be well advised to take that offer, insofar as I can see a finder of fact determining that both parties were equally negligent. On the other hand, I have seen fact finders do all sorts of interesting things on this matter of comparative negligence. The instant set of facts once again strengthens my approach about parking lots. Insofar as I absolutely never pull into a parking space where I have to back out. I feel so much more comfortable going forward, and reverse is just not for me. Let's face it, old folks like me shouldn't back up their vehicles in parking lots as well as most other places. So, great answer, and I thank him for that answer and this little sort of intellectual women's sally has been great fun. So on that note, I'll say bye-bye, YouTubers.